Welcome to See Crime Stories, true stories of the missing and the pursuit of answers. In 5 seconds, here's the case. A 23-year-old mother leaves no note, leaves no trail, and leaves a silence that data can't explain. Bolingbrook, Illinois, Sunday night, October 28, 2007. A young wife, Stacy Ann Peterson, is last seen at home. By morning, her blue SUV is located at Clow International Airport. No ticket purchased. No boarding record. No check bag. Her phone activity stops. The opening picture is not a crime scene, it is an absence. Did she walk away, or did someone write that story for her? Tonight, we follow the data, not the rumors. Investigators start where all nobody cases start, time. They fix the last credible sighting, then press outward, home to driveway, driveway to roadway, roadway to the airport lot. They request airport logs and camera angles that cover entrances, exits, and parking rows. Nothing places Stacy past the curb. Airline systems show no purchase in her name or common aliases. That matters. When a person intends to disappear by air, the paper trail fights back. Here, it doesn't. The second lane of inquiry is digital. Call detail records are pulled, tower pings, last outbound text, voicemail checks. The pattern is short and ordinary through Sunday, then dead air. Investigators know that phones tell on people. They also know phones can be staged, left in cars, powered off to mimic a voluntary exit. The goal isn't to assume, it's to match the human story to measurable time. At the house, there's no forced entry reported and no blood patterning disclosed to the public. That's crucial for your understanding. This isn't a scene-driven homicide opening. It's a missing person case with a car in an airport lot and a silence that starts on a specific night. From there, detectives move to interviews. They separate timelines, family, friends, neighbors, they map contradictions, they compare statements against toll readers, retail timestamps, and neighborhood surveillance. One incongruity draws attention, the airport narrative lands soft, but the data land hard. Who is missing is as important as how. Stacy is 23, mother of 2 at home, stepmother to 2 more, and the 4th wife of a local former police sergeant. That biographical detail doesn't prove anything, it establishes context. In cases like this, investigators build an orbit map, intimate partners, last contacts, anyone with access to vehicles, devices, or schedules. The first objective is simple, locate Stacy alive. The second, if that fails, is to decide whether a crime occurred without a body, without a weapon, and without a traditional scene. If you live in a quiet suburb, you know what vanishes after a case like this, certainty. Streets look the same, the air sounds the same, but routine stops feeling routine. Viewers who've followed nobody cases know the question we ask next. When the car points us to an airport yet no flight exists, where should the search truly begin, at the lot, or back at the clock? The first real break in this case doesn't come from tape or fingerprints. It comes from timestamps. Detectives lock the Sunday evening window and push every measurable edge, phone activity, device checks, and anything the airport can show about cars that enter, stay, and leave. In a missing person file without a body, the question isn't what happened in the house. It's what does the clock say outside it? Call detail records are pulled with consent or warrant, routine in a disappearance with credible risk. The pattern is quiet but orderly through Sunday, then the line goes still. No follow-up calls to friends. No texts to explain an unplanned trip. No voicemail pings after the last verified use. That silence matters because it narrows the window in which a living person could still be moving of their own choice. It also matters because silence can be staged. Phones get powered down, left in cars, or abandoned where they can tell the wrong story. The job is to match device behavior with the physical world and see if the story holds. At Clow International Airport, investigators work through a second layer. Does anything place Stacy inside the facility? Airline systems are checked for the basics: ticket purchase, reservation number, payment method, boarding scan. There's nothing for her legal name and nothing obvious under common variations. In air travel, money and identity leave marks. Here, there's no mark to follow. Parking operations are then mapped for coverage, which rows are under camera, how long cars typically sit before a sweep, what records exist for gate movement. The vehicle is located, but there's no boarding evidence to correspond with it. In towns like Bolingbrook, a case doesn't need drama to be serious. It needs inconsistencies. And the airport narrative starts to bend. Interviews continue in parallel. Timelines from family and neighbors are recorded separately and compared against what the devices and the lot can prove. Routine checks, store receipts, traffic cams near key intersections, tollway readers are used to see who was truly on the road that night and when. In many investigations, the data align loosely and you work the margins. Here, the alignment looks almost too clean. The car points you to an airport, the air records point you nowhere. Sometimes that's the problem. Digital forensics expands beyond calls. Investigators consider account usage that commonly follows any decision to flee, bank withdrawals, card swipes, rideshare requests, hotel bookings, fresh logins from unfamiliar IPs. Nothing public indicates a funded getaway. No paper trail of tickets. No short-term room on a credit card tied to her. A voluntary disappearance is possible in rare cases without money moving, but it's not probable. People buy gas. People eat. People check in. The lack of post-Sunday life signals here is its own kind of signal. Inside the home, nothing publicly released suggests a violent scene. That constraint guides tone and decisions. Without a crime scene, you don't leap to homicide. You work a missing person file with rigor and you protect the integrity of what you do have: last sighting, car location, device silence. The airport detail can't be taken at face value just because it sounds plausible. It has to be tested against systems that don't care about stories, ticketing databases, boarding logs, and timestamped optics. So far, they don't validate the idea that Stacy left by air. What viewers should understand is how this shapes search priorities. You don't concentrate on terminals when there is no record of a traveler. You widen the corridors between the residence and the lot. You ask if the car was driven there by the missing person or staged to be found. You look for cameras on feeder roads, retail exteriors, and neighborhood approaches known to hold footage longer than a day. You check whether the vehicle's placement matches typical patterns or stands out as deliberate. These are not sensational questions. They are the questions that keep a case from drifting. There is also the human scale. A 23-year-old mother, 2 children at home, a routine abruptly severed. In suburban cases, the difference between a person who left and a person who vanished is almost always written in friction with the basics: money, transport, and the phone. Here, those basics don't support the airport exit. That isn't proof of a crime, it's proof that the first explanation doesn't fit the measurable record. For a community that wants clarity, this is the sober reality: when the data won't take you to a gate, you go back to the clock and start again. The airport story fails validation. The car is there, the traveler isn't. That single mismatch reframes the search, the interview strategy, and what voluntary means in practice. It also sets up the next turn, because when a fresh disappearance won't balance on its own, good investigators ask what earlier event in the subject's orbit might still be exerting force. In some files, an old case is noise. In this file, an old case becomes the next lead. 3 days into the missing person investigation, a prior death in the same orbit resurfaces. It is not rumor, it is paperwork, reports, photographs, and a manner of death checkbox that once read accident. The name is Kathleen Savio, found in March 2004, face down in a tub with no standing water. For years, that file rested as a domestic tragedy. Now, with Stacy and Peterson missing and the airport narrative failing validation, seasoned detectives ask a narrow, procedural question: does the older case contain anomalies that, if reconsidered, could explain the present one? The 2004 scene was simple on paper. Responders documented a locked residence, a bathroom without signs of struggle obvious to the first eye, and a body discovered near the drain. No 911 recording in the public record narrates panic from that moment. There's only the paperwork. Early reviewers saw a slip and fall in a tub. But tubs that allegedly overflow tend to leave water lines and swollen baseboards. In the Savio file, the walls and flooring did not tell that story. The absence did not trigger a homicide classification then, but it stayed on the page like a blank the room could not fill. When a prior death sits near a fresh disappearance, a competent agency does not jump ahead. It audits. The audit here starts with scene documentation, photos, sketches, and the timing of the discovery, then the autopsy protocol, injury inventory, and any toxicology. Examination notes from 2004 list injuries that could be consistent with an accidental fall but also do not rule out external force. There are no ligature marks recorded that would simplify the question. There is also no consistent water evidence to support drowning from a full tub. This is where training matters. You do not rewrite old conclusions because a new case is loud. You test each point the old conclusion rested on. Chain of custody becomes the next concern. For any reconsideration to hold in court, the original evidence has to be traceable, sealed, and intact where it is supposed to be. Detectives log what remains: autopsy slides, photographs, tissue samples, clothing if any was retained. They determine whether the jurisdiction can petition for exhumation. The threshold is not curiosity, it is cause. Here, cause builds from two tracks: discrepancies in the original scene narrative and the proximity of that death to today's missing person file. If a pathologist can re-examine injuries with updated methods and either corroborate the original manner of death or overturn it, the effort is justified. The petition to exhume is formal and specific. It outlines what the original autopsy found, why the manner of death classification may be unreliable, and what new forensic examinations are sought: fresh documentation of cranial and cervical injuries, microscopic evaluation of hemorrhages, and any evidence of struggle that a first exam could have missed. Judges do not sign such orders lightly. In this context, the nexus between a vanished fourth wife and a third wife who died under unusual bathroom conditions is not framed as coincidence, it is framed as a duty to confirm or correct the record. When the court authorizes exhumation, the work proceeds with method and respect. The remains are recovered under supervision, transported with chain of custody logs, and examined by a pathologist who was not part of the original determination. The goal is not to embarrass earlier authorities, it is to answer a narrow question: was the original manner of death ruling wrong? If yes, the entire trajectory of both cases changes. If no, the older file can be closed with more confidence, and the missing person search returns to the present without distraction. This is also where small observations matter. In a bathroom fatality, you look for patterned injuries that do not match fixtures, for bruising that pre- or peridates a fall, for microabrasions on elbows, knees, or wrists that suggest restraint or a struggle, for hemorrhaging in the neck that points away from slip-and-fall mechanics. You revisit the dry tub problem. If drowning is on the table, what was the water source and where did the water go? If drowning is not supported, what explains the position and the injuries? The answers live in tissue and bone, not in speculation. The team handling Stacy's disappearance does not run the exhumation lab work, but they read the results closely because the conclusion will either expand or narrow the set of credible scenarios for the current case. In towns like Bolingbrook, residents do not ask for drama, they ask for a standard. That standard says you do not call one case solved by borrowing tension from another. But if the older manner of death was wrong, the correction is not academic, it recalibrates risk, motives, and the weight of statements made after 2004. For the families involved, the process is not abstract. Revisiting a grave is painful. Doing it publicly is worse. The work has to justify the harm. When an exhumation is properly authorized and executed, it sends a measurable signal: this is an agency prepared to let forensic evidence correct the narrative. For viewers who follow true crime for more than shock, this is the core value in real cases. You don't win an argument. You document truth. The decision to exhume Kathleen Savio and re-examine her injuries. That act, by itself, is a turning key. It does not answer where Stacy is. It does not identify a killer. It does something more important for the integrity of both files. It reopens the only door that can lawfully change a manner of death. The next step is what the second autopsy found and how that finding reshaped the legal path. The order to exhume is signed and narrow in scope: recover remains, document condition, reassess injuries, and determine whether the original manner of death should stand. The team handles transport with chain of custody logs and independent oversight. There's no drama in the room, just lighting, photography, measurements, and a pathologist who was not part of the 2004 call. The goal is simple: if the first conclusion was right, it will hold. If it was wrong, the tissue and bone will say so. A fresh exam starts with identification and full body documentation. Every visible injury is recorded with scale and angle so it can be compared to bathroom fixtures and floor geometry from the scene file. Internal review focuses on the head, neck, and torso. The question is not could a fall do this, in the abstract. It is, do these injuries match a fall inside that room as documented? The earlier paperwork described a tub with outstanding water and a body position near the drain. A fall consistent with accidental drowning should leave a narrative that aligns with water behavior and impact surfaces. The second exam finds the narrative does not align. Pathologists do not argue cases, they describe patterns. The documented injuries and their distribution are inconsistent with a simple slip and fall scenario in that dry tub. The absence of water evidence becomes more than a curiosity, it undermines the mechanism originally presumed. When you cannot reconcile injuries and environment, you revisit the manner box on the death certificate. This is how a cold classification changes, not by speculation, but by contradiction between the body and the room. With those findings, the reviewing authority updates the manner of death to homicide. That single administrative act has legal force. It shifts a 2004 domestic fatality into a criminal homicide and, in turn, moves investigators in 2007 to treat the older case as an active offense. It does not name a perpetrator. It does not resolve the current disappearance of Stacy and Peterson. It does something else that matters to both files. It validates the decision to look backward to understand the danger forward. Once the manner changes, prosecutors evaluate admissibility issues that will shape any future courtroom. One of those issues is hearsay, whether statements made by the deceased can be considered if conditions are met. After the manner ruling, Illinois law allows a pathway for certain out-of-court statements when the court finds sufficient proof that a party caused the unavailability of the witness. The exhumation and its results do not decide that legal question on their own, but they create the evidentiary platform where the question can be asked credibly. Detectives then rebuild the older timeline with new purpose. They revisit who had access, opportunity, and motive in 2004. They test past statements against the revised forensic picture. They cross-check alibis that were never pressure tested because the case was not treated as a homicide then. In parallel, the missing person search for Stacy continues with the same rigor as before: corridor canvasses, records checks, and digital triage. One investigation no longer distracts from the other. The older homicide now explains why the current disappearance cannot be minimized as a voluntary walkaway. For families, this is the hardest pivot. Changing a manner of death is not a headline to them, it is the state telling them their loss was a crime. It justifies grief they already felt and opens wounds they hoped would close. In content like this, we don't sensationalize that pain. We note it, we treat it with respect, and we move the case forward because that's the only way any of this yields answers. Strategically, the exhumation result narrows the field. It raises the likelihood that proximity to the victim, familiarity with the home, and control over schedules mattered in 2004. It also reframes the stakes in 2007. When a woman in the same orbit vanishes 3 years later and leaves a car at an airport with no travel record, the coincidence threshold drops. Good policing isn't about proving connections by narrative, it's about testing connections by evidence. Now the older case has evidence that supports homicide. The open question is how that proof will migrate from a revised death certificate to charging decisions and, eventually, to a courtroom. You can feel the tone shift across the task force. Before exhumation, the 2004 file was a weight in the background, painful but static. After exhumation, it becomes an engine. Witnesses who were peripheral may become central. Prior statements take on different meanings. A timeline that once looked ordinary now reads with pressure points: who was where, who had keys, who had reason to control appearances. And while the public watch list wants answers about where Stacy is right now, this is the disciplined answer law enforcement can offer tonight. The older death is no longer an accident, and that truth is the tool we needed to push both cases forward. The best true crime storytelling serves the living. If your community ever faces a case like this, here's the lesson hidden in the paperwork: systems can correct themselves. A ruling can change when the evidence demands it. Families can get a clearer name for what happened, and investigators can use that clarity to protect others. It's slow, it's technical, and it matters. The exhumation changed one line on a certificate. The law did the rest. Once Kathleen Savio's death was ruled homicide, prosecutors could ask a different set of questions about statements made before she died, about risk in the home, about fear that never got its day in court. Illinois has a narrow path for that, carved in 2008, when a judge finds enough proof that a defendant caused a witness to be unavailable, certain out-of-court statements may be heard. It is not a shortcut. It is a guardrail for cases where silence is involuntary. The legal team starts with foundation. What did Kathleen tell others about threats or coercion, and when? Who heard it, and under what circumstances? They inventory sources with dates, sworn affidavits, prior police contacts, divorce filings, contemporaneous notes, and corroborating witnesses who can anchor each statement to a time and place. The point isn't to flood the record, it's to meet the rule's threshold so a judge can decide whether a jury may listen. Defense is ready to challenge every line, as they should. The hearing is the first crucible. What comes in, stays in. Detectives run the parallel track, evidence that does not depend on a voice. With the homicide ruling, they retest the 2004 access picture, keys, entries, who controlled the home, and who was present or accounted for in the hours before discovery. They compare travel windows, phone use, and practical logistics against the injuries described in the second autopsy. They tighten the 2007 disappearance timeline with the same discipline, because a prosecutor who intends to charge in one case must be prepared to explain why the other remains open but highly relevant. The cases are not blended, they are sequenced. One is a homicide file with a body. One is a missing person file with a car and a clock. Back in court, the hearsay fight is sharp. The state argues that certain statements should be admitted because the person who made them can no longer testify, and there is evidence the defendant bears responsibility for that unavailability. The defense argues unreliability, bias, and the danger of letting accusations stand without cross-examination. Judges don't accept hearsay lightly. They weigh context, consistency, and corroboration. When the ruling allows some statements in, it doesn't hand the state a verdict, it gives the jury lawful access to history the deceased recorded in life. With the evidentiary lane set, the case goes to a grand jury. That's where testimony and documents are presented in secret to test probable cause. Grand jurors are not asked to decide guilt beyond a reasonable doubt, they are asked whether there is enough to bring a charge and move the case into the open. By 2009, the answer is yes. An indictment issues in the Savio homicide, and the story that had been stuck in 2004 is suddenly current again. It's pressure the system rarely applies unless the record can take it. For investigators working the disappearance of Stacy and Peterson, this moment matters for another reason. A homicide indictment tied to a death in the same orbit reframes risk. It tells you to treat the missing person file like a case with a high likelihood of foul play even if you still lack a scene, a weapon, or a body. Search priorities stay disciplined, corridors, staging possibilities, and data that do not depend on confession. But you also widen the lens for tip-driven recovery efforts, because a charged homicide tends to move people who were silent before. In communities like Bolingbrook, this is when the case stops feeling like gossip and starts feeling like duty. Jurors will eventually be asked to separate rumor from record. They will see the autopsy photographs, hear from experts who didn't work the first call, and listen to statements the court has deemed admissible under a difficult rule. They will not hear about Stacy as proof of a homicide in 2004. They will hear about Savio to decide Savio. That separation is essential. It's why the missing person investigation remains its own lane, with its own proof burden and its own daily work. From a narrator's chair, the tension here is real but contained. You have a case that finally has a courtroom, and a case that still has a question no court can reach without a body or direct evidence. You also have families who carry both truths. If you've watched enough of these, you know how fragile the balance is. Let the jury hear what the law allows, let the investigators keep pushing for the living and the lost, and let the process be the process. It's not fast. It's not cinematic. It's the only way to turn a one-page accident into a homicide that can be tried. There's a human point worth saying cleanly. Systems earn trust when they correct themselves in public. The decision to admit certain pre-death statements is controversial by design. It demands caution and careful judging. But for a victim who can no longer speak, it is sometimes the only way their warnings do not die with them. That is not rhetoric. It is the narrow space the law keeps for cases like this. As the indictment posts and arraignment calendars are set, the message to the missing person task force is simple: keep going. The courtroom can resolve what happened to Kathleen Savio. It cannot answer where Stacy is. The public wants both outcomes, justice and recovery. So do the people doing the work. Jury selection finishes and the ground rules are clear. This is the Kathleen Savio homicide, tried on evidence that survived time, not on rumor. The prosecution opens with structure, what the second autopsy documented, how those injuries don't match a slip-and fall in a dry tub, and why the official manner of death changed to homicide. The message is not theatrical. It's method. When the body and the room don't agree, the certificate changes. Experts go first. The pathologist who performed the re-examination walks the jury through photographs and injury patterns, comparing contact points to the bathroom's geometry. The testimony stays in plain English: distribution of wounds, absence of water indicators, and why accidental drowning isn't supported. Cross-examination presses on uncertainty. Could a fall produce some of these marks? The expert doesn't oversell. Some injuries can happen in a fall. The set of them, in this room, in this configuration, does not. The state then fills the gaps around the science with context allowed by the court: narrow, vetted statements the deceased made before her death, admitted under Illinois' limited hearsay pathway. Jurors learn about fear, about control, and about domestic volatility close to the time frame of the fatal event. Defense answers with credibility attacks, memory fades, bias enters, and hearsay is dangerous. The judge reminds the jury, you decide weight, not just admissibility. What's missing is almost as important as what's present. There's no recovered weapon, no eyewitness to the fatal moment. That's common in bathroom homicides. The room offers privacy and the timeline shrinks. To offset that, the prosecution leans on logistics, access, opportunity, who controlled the home, and how the discovery sequence fits or doesn't fit ordinary routines. The story that once passed as an accident now sounds engineered, a scene too neat, a narrative that can't carry the weight of the injuries. Defense counters with alternative explanations. Accidents happen. Grief and hindsight can turn any tragedy into a theory. Experts can disagree in good faith. They emphasize the first determination from 2004, when another set of eyes called it accidental, and they asked jurors to value the original proximity of that decision. The state closes that door by mapping each original assumption to the physical record and showing where the record fails to hold it up. You don't need two experts to say homicide if the room and the injuries already say it. The court keeps the Stacy and Peterson disappearance at arm's length. Jurors aren't asked to decide that case and aren't invited to convict in 2004 because of 2007. Still, the reality of a missing fourth wife is no longer a rumor outside the courthouse. It lives in the background as a public concern, while the instructions keep it separate in the box. The discipline is essential. One file is a homicide with a body. One file is a missing person case that, to this day, has not produced a recovery. When the lawyers rest, the jury has 3 piles on the table. 1. Reautopsy science that contradicts an accidental fall. 2. Legally admitted statements that give motive and risk its voice. And 3. Opportunity evidence that explains how the fatal event could occur without outside intrusion. Reasonable doubt isn't a slogan, it's a standard. The question is whether doubt remains reasonable after the body, the room, and the timeline are laid side by side. Deliberations take time but not forever. In 2012, the verdict lands, guilty in the homicide of Kathleen Savio. Sentencing will follow in a separate proceeding, but the core is decided. A death once labeled an accident is now a murder by law and record. Outside, microphones collect statements. Inside, the system records a correction that began the moment Stacy went missing and investigators refused to let an older file stay ambiguous. For those following both lanes, here's the balance point: the trial resolves Savio. It does not answer where Stacy is. Her case remains open, and the search remains necessary. The verdict matters because it validates the risk assessment that kept her investigation in the foul play column. It isn't closure for 2 families. It's accountability for one, and a reason to keep working the other. The verdict came first. The sentence followed. In 2013, the court imposed a long prison term for the Kathleen Savio homicide. On paper, that's the end of one question, accident or murder, and the beginning of another: what a convicted offender does when the law is no longer hypothetical. The answer arrived 3 years later, not from a lab, but from a prison tier. Investigators learned of a murder-for-hire solicitation aimed at the elected prosecutor who tried the Savio case. The allegation wasn't gossip traded through bars, it was a controlled operation. Corrections intelligence flagged conversations. An inmate cooperator and law enforcement coordinated contacts. Communications were monitored lawfully. The point wasn't to score headlines. It was to test whether talk would turn into steps that showed intent, names, methods, payment, timing. When those boxes start to fill, agencies move from rumor to charge. In 2016, a jury heard that Rickard and returned guilty on solicitation of murder for hire. Another sentence stacked on top of the homicide term. For families, none of it brings back a loved one or answers where Stacy and Peterson is. But it does something practical for public safety: it removes any doubt about ongoing risk. When a convicted defendant plots to harm the prosecutor who secured the verdict, the system sees it as consciousness of wrongdoing, not as a new chapter in an old feud. Courts treat it with the weight it deserves. Why does this matter to the still open disappearance? Because it clarifies posture. From day one, the Stacy file has lived in the space between missing and murdered, with no recovered body, no public crime scene, and no direct forensic strike to end argument. The 2012 conviction and the 2016 solicitation case don't solve that absence. But they shape credible perceptions of danger and control. They tell investigators and the public that the risk assessment that kept Stacy's case on a foul play track was not overcautious. It was necessary. Operationally, the sentences also change resources. A high-profile offender serving long time is easier to monitor, and tips tend to surface when a case is back in headlines. Task forces use those windows to recanvass old corridors, to ask correctional contacts if any inmate has heard talk about locations, to revisit disposal theories that were low probability in 2007 but better informed now. This isn't movie work. It's callbacks, database pulls, and interviews with people whose incentives shift over years. Sometimes a person who said nothing in 2008 will talk in 2016. Sometimes not. You plan for both. There's also a duty to the community. People who followed the trial often ask what justice means when one victim's case results in a verdict and the other remains open. The sober answer is that systems do both jobs at once. One courtroom delivers accountability for Savio. Another team keeps looking for Stacy. Sentences deter, protect, and signal. Searches preserve hope and evidence. Those lanes do not cancel each other. They make the work coherent. From a narrator's seat, Here's what matters tonight. Long after cameras left the courthouse, monitored conversations in a prison confirmed ongoing threat beyond the 2004 homicide. That outcome didn't add spectacle, it added certainty. And certainty is the rarest resource in a missing person investigation that has asked the town to hold two truths at once for nearly 2 decades, guilty for one case, unresolved for the other. Cold case work after the verdict isn't about retelling the first week. It's about testing what time has changed. Through the 2010s into 2025, investigators kept Stacy and Peterson's file open and active, rescreened tips, scheduled anniversary canvasses, and revisited people whose loyalties or life situations had shifted. Lists were rebuilt, not to inflate paper but to sharpen questions: where the car could have been before it reached Clow International Airport, which corridors lacked cameras in 2007, which storage yards, spoil sites, or water access points were realistically reachable inside the known window. When a lead met threshold, teams documented, searched, and either advanced it or closed it cleanly. The case log grew with disciplined entries, not theories. Technology changed the toolkit, not the facts. Older call detail records were remodeled with better sector analysis. Where lawful and available, ALPR archives were queried for vehicles tied to the orbit. Private video aggregators sometimes filled gaps that didn't exist in 2007. On the water, comparative side-scan sonar helped distinguish what was new on the bottom from what earlier passes missed. None of this created a recovery. It created a tighter map of what remained plausible. That matters in a nobody disappearance. You narrow the field until the wrong stories can't stand. Community pressure stayed part of the operating picture. Public appeals were timed and specific: dates, corridors, discrete items, enough to jog memory without burning investigative value. Families carried grief without spectacle. Agencies kept key details sealed. After the 2012 homicide verdict for Kathleen Savio, the 2013 sentence, and the 2016 conviction for solicitation of murder for hire, more calls arrived. Most were noise. Some justified digs, pond work, or targeted searches. Each was logged with result and rationale. The point was never volume. It was signal. Legally and ethically, the lanes stayed separate. Savio is adjudicated, re-examined, reclassified, tried, and sentenced. Stacy remains missing. No body recovered. No charges filed in her disappearance. Keeping that separation protects both truths: a homicide proven in court, and a disappearance that must not be patched with speculation. It also keeps the work coherent. One file preserves a verdict, the other demands patience and precision for a break that hasn't come. There is a human message here, and it's brief. Systems can correct themselves when evidence demands it. Families deserve that. Communities can help without rumor. Specifics matter: a date, a location, a vehicle, an item that didn't make sense then. If you lived near Bolingbrook in late October 2007, and there's a place you used that week, road, water access, storage, that you've never mentioned, now is the time to put it on a map for investigators. Small facts close large gaps. I've told this story as straight as I know how: facts first, dignity always. Here's my takeaway: when someone goes missing, silence is not neutral. Document what you see, trust your gut, and speak up early. Justice moves slowly, but it moves because ordinary people share specifics, not rumors. What did this case make you rethink about safety and accountability? Drop your thoughts, and tell me where you're watching from. If this resonated, subscribe to the channel for more real cases. If it didn't, say why. Your voice helps us do better and keep these stories alive.